In 2022, the US Supreme Court, in Dobbs v. Jackson Women's Health Organization, overturned its own decision of 1973 in Roe v. Wade. Roe v. Wade recognized the existence of right to abortion in the US Constitution, and Dobbs found that there wasn't any such right in the US Constitution. And what is interesting is that everyone thinks it is globally relevant, globally important. Why is that? Well, clearly, it is very relevant, very important for the American population. No two minds about that. It is also relevant for those populations that, for reproductive rights advocacy, for health security, depend on American-based funding, for example, via global NGOs, because this might affect the funding availability in the future should Dobbs be any sign of how US policies will develop, which it probably isn't. There seems to be an assumption here that whatever the US do, it's globally relevant because the US is such a powerful actor. It's not a dancer. The US sets the dance floor for the rest of the world. If they go more restrictive on abortion, everybody else will also go more restrictive, and the other way around. Well, this clearly be too simplistic. Of course, some countries might go more liberal on abortion when the US go more restrictive to show that they are more progressive, that they go with times, and the Americans just got stuck somewhere in the past. There are also jurisdictions which may decide to go more restrictive on abortion because they don't want to take American lead. So even if the Americans liberalize their abortion laws, the others in some parts of the world will not follow suit. There are all sorts of complexity here, but whatever level of complexity you pick, there is an idea that the US is a reference for the global development in legal governance of abortion. And there is a problem here, because if we look at it that way, well, there is another frame, another global frame, relevant for legal governance of abortion, which is the frame of universal human rights. So how does the American order stand vis-à-vis the universal human rights? We find that there is indeed very little interconnection. I have once used the concept of a jurisprudential horizon, and commenting on the 2020 decision of the Polish Constitutional Court that limited the right to abortion in Poland, I have argued that this was a case of a closing jurisprudential horizon. If you think about the jurisprudential horizon as a pool of arguments from which reasons may be drawn for a court decision, then closing of a jurisprudential horizon means narrowing down of this pool, limiting the scope of arguments, so there is less and less you may pick up. And the closing, in the case of the Polish constitutional judgment, consisted in refraining from addressing anything that was beyond the domestic legal order. And we find the very same thing in Dobbs. Dobbs is also not referencing anything that is beyond the domestic legal order. It has very little connection to the universal human rights. This is an argument that has been raised against Roe already in the 70s. There is not much difference in the sense of staying within the American tradition, be it the tradition of the civic rights, as in Roe, or the history and tradition of the nation that is stressed so much in Dobbs. And if we think about Dobbs as a closing in of jurisprudential horizon, then this is indeed a reason why Dobbs is globally relevant, not because of the outcome of the jurisprudential reasoning, but because of the way that the court's decision is reasoned.